configure the because.
Okay, so I started it.
Okay.
First of all, good morning and good afternoon for those of you joining us from Europe. I am pleased to welcome you to a new edition of the Wolep webinars dedicated to the legal profession. Today we are tackling a very topical subject, namely whistleblowers, their importance and the legal regulations that concern them, both in the United States and in Europe. To this end, we have invited three lawyers who are experts and are also friends of the Wolep network from both sides of the Atlantic to share their expertise on the subject. So please let me introduce you to our three speakers today. First of all, Mr. John May, joining us from Florida, the United States of America. He practices federal criminal defense throughout the country. Mr. May has handled some of the most important criminal cases of the last 3 decades. And I would like to pinpoint some of them. His defense of General Manuel Antonio Noriega trial, his challenge to Florida's election law during the contested election of George W. Bush in 2000, his representation of the American Civil Liberties Union in the battle over Rush Limbaugh's medical records, and more recently, his representation of Venezuelans accused of stealing billions of dollars from the Venezuelan government and an alleged Chinese intelligence agent accused of attempting to steal US military secrets. Attorney John May has and remains at the cutting edge of criminal practice in the United States. So, thank you, John, for accepting your invitation. Just a second, because I will have to ask someone to mute himself. Secondly, Mr. Mark Stephen Raspanti, joining us from Philadelphia, United States. Welcome, Mr. Raspanti. He's a seasoned litigator with over 38 years of experience focusing on complex, high-stakes matters in areas such as government enforcement, compliance, internal investigations, federal and state white-collar litigation, federal and state quitam litigation, criminal, civil, and administrative healthcare fraud litigation, and complex commercial litigation. He is a fellow of the American College of Trial Lawyers. He is also a former prosecutor with the Philadelphia District Attorney's Office, where he tried a wide range of criminal cases to verdict. Mark is a named partner of Pietragallo, Gordon, Alfano, Bosic, and Raspanti, LLP, and the founder of the firm's National Quitam False Claims Act Practice Group, as well as the firm's National White Collar Criminal Defense Practice Group. Mark has been described as one of the best white-collar criminal defense lawyers in Philadelphia by Philadelphia Magazine. He was selected by his peers annually since 2004 as a Pennsylvania super lawyer. He's a member of the Pennsylvania Association of Criminal Defense Lawyers, the National Association of Criminal Defense Lawyers, the Society of Corporate Compliance and Ethics, and serves on the Federal Bar Association's Quitam section. He is also a member of the Federal Criminal Law Committee for the Eastern District of Pennsylvania. Within the American Bar Association, Mark currently serves as the national co-chair of the Criminal Justice Section White Collar Subcommittee on Quitam litigation and has served on the Committee on Complex White Collar Criminal Litigation. He is also a long-standing member of the National Italian American Foundation. I would like to again welcome Mark and thank you for accepting our invitation. I know I cut short your resume.
No, thank you very much.
It's huge, so it will take probably the first half an hour to read it comprehensively. And thirdly, joining us from Bucharest, Romania, is Mr. Gabriel Albu. He's the founder attorney of Albu Legal, a boutique law office specialized in white-collar crime that was launched in 2020 and had outstanding results in the white-collar crime practice area for the past couple of years. In the last 4 years, so from 2019 onwards, Gabriel Albu was ranked as a leading individual in white-collar crime by the prestigious top The Legal 500. Gabriel has a strong professional experience acquired in multinational law firms like Linklaters, CMS, Cameron, McKenna, and Salons, as well as in independent practice. He has a solid and diverse experience related to the corporate field, assisting and representing a large number of companies, multinational and local, and also individuals within them in complex criminal proceedings under national jurisdiction and also with international elements. Mr. Albu assisted over 1,000 satisfied clients and accounts for more than 1 billion euros saved. And due to his exposure to high-level clientele and sophisticated and many times cross-border matters, he gained significant experience in various types of international cooperation and litigation procedures. Over the years, Gabriel Albu has been involved in a large number of high-level criminal cases in Romania, and I would also like to welcome him and thank him for his participation. He's a dear friend of mine, so Gabriel, we're very glad to have you on this Wolep webinar. I would also like to welcome all the other colleagues that joined us while I was doing this introduction.
Thank you for the invitation. I'm glad to be here. I'm honored. I'm very delighted of meeting again John, and honored to speak together with Mark here. And welcome to everyone else.
Okay, great. Having said that, allow me to hand over the mic to my colleague John May, who will be introducing today's topic. So, John, you have the floor. Thank you.
Thank you. And I want to express my appreciation to Wolep for giving us the opportunity to provide some education to the European community and lawyers associated with Wolep, because we have in the United States a 200-year history of dealing with whistleblowers, and to the extent that we can provide our experience to the EU, we would like to do so. Whistleblowers play a critical role in law enforcement in the United States. Law enforcement believes that whistleblowers is their number one tool in fighting public corruption and corporate corruption, both here and worldwide. If it weren't for whistleblowers, we wouldn't know the extent to which Putin's oligarchs had taken trillions of dollars out of Russia and distribute them to banks or through banks all over the world. And we would not have been able, to the extent that we have, seized or frozen billions or trillions of dollars or euros in banks, as well as various yachts around the world. In the United States, whistleblowers have contributed to prosecutions of individuals in just about every significant sector of our economy, from securities and commodities to healthcare and the safety of our food chain. The importance of whistleblowers within the corporate community was addressed in a 2007 study by PricewaterhouseCoopers that found that only 19% of wrongful conduct was found by auditors, whereas 43% of wrongful conduct that had cost companies billions of dollars was first uncovered by whistleblowers and would not have been uncovered absent the disclosures made by whistleblowers. The False Claims Act in particular has recovered to the United States over $70 billion of wrongful payments. Just in 2021, the United States government recovered $5.6 billion essentially in overpayments made by the U.S. government to various private concerns, whether it be healthcare agencies, doctors, or military businesses building airplanes, tanks, all kinds of equipment that are sold to the U.S., in which the U.S. spends a great deal of money, and sometimes or oft times without the kind of oversight that would be necessary to prevent these kinds of overpayments to be made. People who are not familiar with whistleblowers sometimes think that they are just in it, trying to get money, like playing the lottery. But in fact, whistleblowers can be some of a company's most loyal employees. In over 70% of the instances where the government has instituted civil or criminal investigations based on the disclosure of whistleblowers, the whistleblower went to their employee first, made the disclosures to their employee first, and only went to the government when they were ignored or fired. And the recoveries that whistleblowers receive usually just cover the cost of getting them back on their feet after they've been fired or blackballed in their industry, lost their income. It takes a brave person to be a whistleblower. And even though you hear sensational stories about a whistleblower who's got $100 million, well, in fact, whistleblowers receive quite less. And again, it's not an insignificant amount of money, but given the risks that they take and the sacrifices they make, it's an honorable recovery for the work that they do. Unfortunately, whether it's in the context of whistleblowers or other aspects of our lives, we seem to learn lessons and heed warnings after people have died and after millions or billions of dollars have been lost. And I want to just leave you with one example before we go on to Gabrielle and then Mark. There was a individual who worked for a company. His name was Kenneth Kendrick in Texas, who uncovered significant problems in the processing of peanuts. And he believed that the peanuts were being processed in such a way that they could endanger the public because of bacteria. Mr. Kendrick went to his company, went to state authorities, went to federal authorities, and was ignored. And this was like back in 2008. And the result was 9 people died, thousands were sickened, and the industry had to recall peanuts at a loss of $1 billion. And the company that produced these dangerous peanuts went under business. If the company had only listened to him, none of this would have happened. Now, fortunately, as a result of this incident, their new statutes were enacted by Congress to prevent this from ever happening. But this illustrates just how critically important whistleblowers can be, not just in prosecutions of criminals, but also just the safety of citizens. So with that, I leave it to our next speaker, Gabrielle.
Thank you, John. Very interesting what you said. Actually, you touched on one of the things that I was meaning to bring forward, as in the PwC report that you referred to, which basically tells us that a vast majority of issues, especially within companies, within private organizations, are brought forward by whistleblowers, and only a few, in comparison, are brought forward by various means of, let's say, internal mechanisms, internal audits, internal investigations, corporate controls, and so on. So indeed, as you are saying, whistleblowers are apparently, statistically speaking, the best means of uncovering types of wrongdoing. And one other, let's say, important thing that you said is that there is a vast difference, both in legislation, in statutes, and even more in practice, between what I perceive to be, let's say, the US status quo versus the European status quo. And this is for various reasons that I will present. So I was, as Theo was himself, quite amazed of the US practice and rewards listed in your draft presentation for this event, as in the impressive list of whistleblowing events and the way they were handled, and the rewards received by whistleblowers, which obviously encourage, let alone compensate whistleblowers for what they are doing. Many times important positive things. In the EU, the situation is quite different in the following sense, but improving. To, let's say, to say the conclusion from the beginning. As we all know, the EU is not exactly, let's say, the most homogeneous organization of them all. Meaning that various states have various perceptions and practices regarding the idea of whistleblowing. To be more precise, for example, the eastern states, the former communist states, tend to view based on their history during the communist times, where people were reporting to the intelligence services, let's say, the wrongdoers against the established order. Generally, whistleblowers are not, let's say, traditionally are not well seen. Whereas, for example, the Western states from the EU are much more accustomed with the idea of whistleblowing, with the positive side of whistleblowing, and the fact that this is a normal and many times positive component of public life. Of public and private life, actually. So what happens now in the EU, and this may be a very, let's say, positive development also for EU-US cooperation in this matter, is the fact that based on a 2019 directive on the protection of whistleblowers, the EU has decided to impose common standards upon the member states for whistleblowers. The directive had as implementation deadline the end of last year, but as is tradition in the EU, the states were not all in that much hurry to actually implement the directive. So only a small number of states have done so by now. The others, from my research, are in more or less developed stages into enacting their own internal legislation based on the directive. As you may know, EU directives are not directly applicable in the internal public order of the member states. They are only meant of obliging the member states to enact their own internal laws to follow the standards listed in the directive, which are seen always as minimum standards. Now, what does, let's say, this directive do? First of all, it defines whistleblowers, and it regulates some very important protections for whistleblowers, meaning prohibition of retaliation, the most important prohibition of all types of retaliation, meaning sidelining, firing, giving bad qualifications at work, any type of, let's say, more covert or open type of retaliation against whistleblowers. As a substantial matter, the whistleblowers can basically tip off either their employees or the authorities or the general public, and I will revert to the types of whistleblowing that the directive regulates. They can tip off, again, either their employer or the authorities or the public in respect of generally all types of breaches of EU legislation. However, as I said, the directive is meant as providing minimum standards. Therefore, many states are considering covering when implementing the directive, many states are considering including national law as a potential breach for which whistleblowing is permitted and covered with the protection provided by the directive and by the respective internal law of that member state. In respect of the types of reporting channels, as they are called, of the types of whistleblowing that are regulated by the directive, it is obvious that the EU directive, somehow consistent with the traditions within the EU, which again are not so open-minded, such as the US statutes and practice, as I understand them from you, the directive obviously favors internal, what it calls internal reporting or internal whistleblowing channels, meaning one whistleblower is, let's say, it's, I shouldn't say necessarily compelled, but let's say at least encouraged through various ways into going first of all to their employer. For example, to give a very specific example on the Romanian implementation of the directive. For example, the Romanian implementation provides a 3 months deadline in which a whistleblower can only resort to the internal whistleblowing mechanism. And if within that deadline their whistleblowing is not appropriately handled, then external whistleblowing or public reporting is allowed. I also as a major, let's say, difference from the US statutes and practice, the letting aside the protections, including pecuniary types of benefits for the whistleblowers, the EU legislation does not mandate in any way or encourages actually in any way awarding any types of rewards to the whistleblowers, aside again from mere compensation for any type of harm that the whistleblower may have encountered following their whistleblowing. This is the reason. This is basically a reflection of the fact that within the EU there are not, let's say, notable cases of whistleblowing resulting in specific rewards, such as in the US. Therefore, all the better in the cases, let's say, let's call them transatlantic cases, whereby whistleblowing of breaches of EU law would also entail interests of the US jurisdiction. The protections, the new protections within the EU may very well align with those in the US, plus the rewarding mechanisms provided by your legislation. Let's say that pretty much this would be the important. Let me say something about the statutes, the status of the implementation of the directive in the EU, as in terms of statistics. For example, only one country did not start the implementation at all, and that is Hungary. Delayed implementation 16 out of 27 of the EU members, and the internal legislation adopted, but not everywhere in force, but probably about to enter into force in 10 of the 27 member states. So let's say that pretty much the implementation process is rather advanced, and therefore the new mechanisms covered by the directive and the respective national legislation will start producing results, basically. So that would be generically the status of the EU legislation on the matter.
Great, thank you. I think John has to unmute himself, please. John, please unmute yourself.
Okay.
Great, we hear you.
The question that I had for Gabrielle is, with this EU directive or initiative, the various states or countries individually have to pass legislation. Am I correct about that?
Yes, quite correct. Again, directives are means to set standards in principle by the EU with the corresponding obligation of each of the member states to pass its own internal legislation to meet at least those standards laid out in the directive.
Okay. Now, once an individual country has created their own legislation, is that legislation in force in that country, or is it delayed until all of the members of the EU have ratified it or have come up with their own individual statutes in their own countries?
When implementing the directive, each state has its own rules regarding entry into force of its own legislation. So basically, it's not that kind of instrument whereby it enters into force only when the last of the states has adopted it. It's individual based. So, and basically the states are also facing what we call here infringement procedures if they are failing to adopt national legislation to implement the directive, or if they adopt it but they neglect the principles in the directive. So basically they are doing something else but the general principles in the directive.
Thank you.
Great. I would also like to thank again Gabriel for his presentation on a very interesting issue on this topic of whistleblowing and whistleblower programs in the European Union. I also have to remark that unfortunately, and I hope you can illuminate this subject, Gabriel, the Romanian Parliament recently adopted a whistleblowing law that is now being contested by some parts of the civil society, because they say, those parties say that it does infringe upon the European directive, and it limits drastically the powers and the freedom of the whistleblowers. Is that correct? If you can unmute yourself, please.
Yeah, sorry, I was on mute. So yeah, you are right. It's quite a heated subject nowadays in Romania. As I said, various member states have different types of, let's say, historic views on the idea of whistleblowing. Romania, being one of the members of the Eastern Bloc, is naturally much more, how should I say, cautious regarding the general permission of whistleblowing around, so to put it. So the Romanian law tended to adopt also some provisions to entail a sort of responsibility for, let's say, wrongful or exaggerated types of whistleblowing. And why is that? And you can see that as a good thing on one hand, as a bad thing, obviously, on some other hand. The EU directive permits whistleblowing to basically everyone, not only to employees, to people doing internships, to even, I don't know, even to the courier showing up at your door and noticing something irregular during your organization. So basically not always someone having a specific employment relationship with that organization. And therefore, the hot topic, legalistic topic on that was, how do you discipline let's say a bad faith whistleblower if that whistleblower is not actually your employee? Because if it's your employee, then you have disciplinary measures against your employee for bad faith whistleblowing, for example. Otherwise, not being your employee, then you need different legal means in order to prevent bad faith whistleblowing or uninformed whistleblowing. Seeing that obviously whistleblowing can also bring negative consequences, for example, public image damages to an organization, which sometimes may be justified, but sometimes may be unwarranted. So again, actually, to put it in more human terms, in a conference, a live conference a while ago on whistleblowing topics, there was a presentation by a gentleman in the Netherlands dealing with a company with managing this kind of whistleblowing channels, whistleblowing reporting channels. And in the Romanian environment there, the topic of disciplining or entailing somehow responsibility of whistleblowers, if they are exaggerating, they are doing it in bad faith, not for the proper reasons and so on, this subject appeared very quickly, because again, the Romanian is the Eastern European environment. Whereas the reaction of the gentleman from the Netherlands was very Western oriented, as in, why are we concentrating on a sort of a presumption of bad faith of whistleblowers? So these are basically the types of very divergent views, practical views between what we can call Western Europe and Eastern Europe. And this you can also see in the actual transposition of the directive, and the Romanian example is a very good one that you brought it up.
Thank you very much, Gabriel. And I think that one of the preliminary takeaways from this Wolep webinar is that there are cultural differences that you pointed out regarding whistleblowing. So it's very interesting to hear that even in Europe, within the European community, there are, like I said, different views on the matter. But there are even more so when comparing the United States and Europe. So that takes me to the second part of the webinar, and moving on to Mark and John's debate. And of course, we are also inviting you to join the discussion, Gabriel. So I'm moving on to Mark and John's presentation. Is it okay now, John or Mark, to share the
Sure. Can you hear me all right?
PowerPoint? Yeah.
Great. So let me just first say, I enjoyed listening to Gabriel, because for the first time, I had a learned articulation of the non-American view to whistleblowing. Over the 32 years I've been doing American whistleblowing, I've had the great opportunity. My family emigrated from Italy. I have a lot of immigrants still around, and so I get a chance to be steeped in European. I spent a lot of time working on cases in France, in Belgium, in other countries, and having the opportunity to interact with European lawyers, EU lawyers, Estonian lawyers. And I came away and started to write some articles, because I really knew nothing about the rest of the world's whistleblowing practices. And I came away with the exact conclusions that now Gabriel. So I felt that I'd been on the right side And every time I would leave a country and have a drink with a colleague, they would explain to me that something's in the works. We're thinking about it. We don't like this. You talked about the Eastern Bloc countries. The Germans don't like whistleblowing so much either. And so, they often add a lot of things that makes it very difficult. So I'm now going to spend a few minutes and try and consolidate in the few minutes I have well over 150 years, some can argue over 200 years of whistleblowing culture. And so many of the things that Gabriel has mentioned for all of the countries have been debated in our country, which I frankly think is not so homogeneous anymore either. So every single item that you've talked about over the years have been debated openly in our Congress. But what we have come up with, and I'm going to ask you if you could, Tio, to put the slides up just to help the audience follow. All of our whistleblowing statutes really emanate from the False Claims Act. And the False Claims Act actually was passed by President Lincoln in 1863. And it actually has its origins back to the founding of the American Republic. Literally, there were whistleblowing provisions at the time that the colonies started. But the modern False Claims Act really was passed in 1986 under President Reagan. And I'm going to start there because the success of the American whistleblowing statutes all flows from the False Claims Act. Sometimes people refer to the whistleblowing provisions as quitam provisions, which is a Latin phrase meaning someone who brings it on behalf of the king. And that is what's referred to a quitam or later a whistleblower. But there are 5 major elements that have made our whistleblowing statute successful, and I think frankly has derailed many of the European efforts over the years. And let's start with the statistics. Since 1986, as John mentioned, we have recoveries of almost $71 billion. And of the $71 billion, awards were made collectively to whistleblowers of $8 billion. That should get someone's attention. So the first thing about the False Claims Act that makes it unique, it's a statute. It's an actual statute, a law passed by the Congress. And it gives actual rights to the whistleblowers. And one of the rights is that they are guaranteed a minimum and a maximum amount of recovery of between 15 and 30% of what the fraud may be. Number 2, the False Claims Act in 1986, very, very strong anti-retaliation provisions were added to it to protect the whistleblower. Some of the European statutes, frankly, are always looking to hurt the whistleblower if he or she makes a mistake. And that's a gross assessment of them. But in our statute, you could make a mistake and still be protected as a whistleblower. Number 3, which almost does not exist in many of the European statutes that I'm aware of, whistleblowers have the right to have attorneys. And if they're successful, those attorneys can have their fees and costs paid by the offending company or defendant. The next provision, which does not exist throughout the European Union, is that there are active government agencies and devoted prosecutorial professionals who know how to enforce this statute. And lastly, like some of the European statutes and EU statutes, there is a broad class of persons who can become a whistleblower. But the key point for all of our statutes is you do not have to be an American citizen. You do not have to be an American citizen. So that is the False Claims Act. If we could move now our slide to some of the other key statutes that exist. So the Securities and Exchange Commission, which is a very powerful commission in the United States, and it works hand in glove with the Futures Trading Commodity Commission. And those take care of a large bulk of the American economy. And so as a result of the success of the False Claims Act that we just discussed, that had a long history going back to 1863, the Securities and Exchange Commission passed a statute, and that statute has been a tremendous success. And it's only been on the books for 18 years. $1.1 billion went to whistleblowers, $5 billion in recoveries. And for the first time in history, last year, the SEC paid out $564 million to whistleblowers, and that doubled what had been paid under the False Claims Act, which no one ever think would happen. The good thing about the difference with the SEC program is, and the next program that'll also come up, if you can advance the slide, having to do with the CFTC, is it's a reward program. It's a reward program, meaning you go to the agency, you can file it anonymously, you don't have to be an American citizen. They take your information. They want your information to be unique, but it doesn't have to be exclusive. And if the commission uses that information, it leads to a recovery, the whistleblower can be awarded. And unlike most American statutes, I must say, the Securities and Exchange Commission and the Commodities Futures Trading Commission outline the ways in which you file these cases and monitor these cases about as clearly as I've ever seen in a statute. And according to the statistics that we've been able to find, the SEC under the last two administrations, and it's been kind of whether it's been a Republican or a Democrat in Congress or at the White House, have been getting tips all over the world. So those two statutes work very well. And you can see by some of the slides what's up there. You have the opportunity to file it anonymously. So there are times where the whistleblower's identity have never been identified, but you do have to be an individual, which is a distinction from the FCA, the False Claims Act, where a company can be a relator or can be a whistleblower. If we could advance our statute, please. Under both the statutes, they picked up the strong anti-retaliation provisions that were added to the False Claims Act in 1986. Before 1986, whistleblowers were tortured, to be honest with you. And I'm happy to hear that Gabriel mentioned that throughout many of the statutes in the EU, they are adding those provisions to provide protections to whistleblowers so they come forward. Now, the United States, unlike many of the European countries and many of the EU countries, are not a single payer system. And I'm dealing with healthcare. So in Europe and in many EU countries in healthcare, there's one entity that pays. Keep in mind, in the United States, there are many entities that are paying healthcare. And I'm just dealing with healthcare because that's what I spend a lot of time on. So it's a little bit more complicated in the United States. But what the United States has attempted to do in its statutory functions is to close the gaps to follow where the money goes. The False Claims Act deals with federal funds. And we don't really have the time to talk about it, but 32 states have passed their own False Claims Act statutes, and they take care of non-federal funds to the most part. If we can advance the slides. So this is the Commodities Future Trading Commission. This deals with derivatives. This deals with all kinds of commodities fraud. Between the SEC and the commodities area, we're looking to find companies, both private and public, who may be engaged in fraudulent activities, that may be cooking the books, that may be doing all kinds of things that they shouldn't be doing. I want to go to the last statute and then give you a firm example of how non-Americans can kind of use it. If we advance the slide, we'll go to the last of the major reward systems, and that's the Internal Revenue Service. And I think most of us in America who practice under these areas are disappointed with the IRS whistleblowing system. The IRS, which is our main taxing entity, has never been the most transparent of entities. They're underfunded, and the way it works, unlike the Securities and Exchange Commission, which has much more transparency, is you file a claim, it could go into a giant hole, and you hope that the IRS does something with it and you get a reward. It has not been as successful as some of the other systems in the past. So those are the basic bedrocks of what I would call American whistleblowing statutes. And let me just kind of give you an example of how Europeans have decided, at least from my vantage point, that their statutes are not where they need to be, or European or EU authorities have not yet embraced both the idea of whistleblowing or the rewards. As Gabriel mentioned, the pecuniary awards are sometimes non-existent or are sometimes not worth the effort or the potential risk. And I handled a case a number of years ago with another law firm in which an individual, it was a public case, his name was Michael Epps. He was a German citizen. He was an employee of a giant American food company. He was based in Dubai, but the company was supplying food to American troops in the Middle East. So if you kind of follow that, it was an interesting matter. And he decided, after reviewing the laws in his own country and some of the other countries, that he would contact American lawyers and take advantage of the fact that there were better statutes on the books here. To make a long story short, he worked very closely with the FBI, with the Department of Justice. We would fly him in at the end of the case. He was living in the Philippines. He ended up settling that case for over $101 million, and he received a reward of $16 million from the United States government. So that's kind of a summary of the way our statutes have worked. Years ago, I wrote a article, and I've given some of the articles I have written just as background, and I compared a few of the other statutes of other countries. And I am in touch with my colleagues because I like to see if things are moving. I think the EU is moving in transparency statutes more and more, and in anti-kickback statutes. I think that I'm going to use a word from my colleague, Gabriel. I think that they are policies and directives, and I think where they have fallen short is in implementation, at least from the American point of view, or from my point of view. So my advice, perhaps, to willing nations would be to take a close look at the False Claims Act, which does have a long history. It's made its way back and forth to the Supreme Court of our country a number of times, and it's held up rather well. I'll turn it over back to you, Theo, and answer any questions anyone might have.
Thank you very much, Mark. To our attendees, I think you now have a better idea of why trying to print Mark's resume jammed our printing machine. So thank you for the expert analysis, Mark. It was very, very interesting and illuminating for all of us here in Europe, because seeing the diversity and the complexion of your whistleblowing programs is truly inspiring, and I think Gabriel can agree with me on this.
Actually, not only agree, but I would like to say something more and maybe make use, since I did that presentation, which I didn't share. Maybe let's make use of it in order to be rather clear, as in both resemblances and sort of a comparison with what Mark said earlier.
Sorry to interrupt you, Gabriel. We'll share it with all the attendees. We'll send it afterwards, so no problem.
No, maybe you can share it now. For
Yeah, sure, no problem.
slide 9.
Just a second, please.
Thanks.
Okay. Slide number 9.
Yes,
Okay.
which is protection measures to be implemented by member states.
Okay, great. Just a second, please. I'll share it momentarily. So, slide number 9.
Well, while you're sharing that, one thing that I think is very interesting that, and I take from the remarks that Gabriel made, and looking at it, I don't have his background, but in looking at some of the statutes, the European states, or the European Union at times wants to punish a whistleblower that might be wrong. Where in the United States, we have eliminated much of the motive and decided if a whistleblower perhaps was wrong, we're going to limit, but not eliminate, the reward to that whistleblower. Because as Abraham Lincoln said in 1863, to catch a rogue, you need a rogue. So that had become the basis of our statute. I don't know if that resonates with you, Gabriel, with some of your.
Well, as I have always seen, the U.S. approaches to things are very pragmatic, whereas
Exactly.
many times the European approaches are some sort of a philosophical ones, more about some sort of esoteric principles sometimes, and so on.
Right.
Now, to be clear, the adoption of this directive and the corresponding obligations of the member states is obviously a huge step forward into devising a whistleblowing system with somehow aligned standards throughout the EU. Now, given that this is at the beginning as a general system throughout the EU, obviously there will be differences, probably significant differences in the way various member states will be treating the matter. And again, those differences will stem especially from their historic and cultural backgrounds. Now, what the directive does very well and what it doesn't, thinking about what John and Mark said earlier. Now, what it does well is the fact that it regulates some very specific protections which the member states will be obliged to implement. I listed them in the slide in front of you. So it's prohibition of retaliation in whatever form, ensuring various measures of support, such as information centers, in some instances, legal assistance, and so on. Also specific measures of protection, for example, protection of the identity when needed. Also imposing the need of the member states imposing penalties against, let's say, company offenders, and against employers if they are breaching the measures laid out in the directive. So there are some very specific protections now as an aligned system throughout the EU. What it fails to do, I think, the directive is the following. First of all, implement a common standard whereby whistleblowers would be punished. as in common standards such as either bad faith or gross negligence, and exclude all other forms of punishing whistleblowers for their information brought forward. And the second, favoring a system of rewards towards those whistleblowers, aside from simply reparations if they suffered various types of harm, such as not being promoted, such as not getting raises, such as being fired and the like. So this would be the shortcomings of the European system as it is laid out right now. However, obviously practice will show what, for example, prohibition of retaliation or reparation measures will mean actually in court practice and national practice. As in, if this will, for example, just let me think of a specific example, because we have somehow discussed it in our preparation, that of an employee taking confidential information from the employer, so information covered by confidentiality agreement, or maybe by some sort of secrecy, trade secrecy laws, or maybe even type of security clearances and so on. For example, to make it clear that the protection awarded to whistleblowers include immunity from the application of any kind of statutes punishing the taking of such confidential information. And here also the internal legislation and practices of the member states will be very important on one hand, but also a future intervention of the European Court of Justice in any kind of infringement procedures against member states, in order for the European Court of Justice, which is the ultimate entity into construing what the principles laid out in the directive are, will tell us that, for example, the protections awarded to whistleblowers will include any kind of immunities, will include entitlement to any kind of reparation or bonuses and so on. So the principles are now laid down, which is a huge way forward. There is still work to be done into actually having thorough guidelines into what these principles will mean.
I think, Gabriel, you might find interesting, and maybe the audience, and underscoring your excellent word pragmatic. There were two things that people might find interesting, and John May knows this. In the United States, if you are a publicly traded company, you are obligated to educate every employee at that company about all the potential protections and whistleblower provisions that are out there. I remember having a heated debate with a French lawyer who couldn't believe that a company would actually educate people to become whistleblowers against it. So that's interesting. Number two, the first time I was contacted, maybe a decade ago or more, talking about pragmatic, I just assumed our statutes precluded non-Americans, but it did not. It actually encouraged them. So that was interesting. And the other point that you made earlier about the integration of violations, and I might be paraphrasing it, but you indicated some of the statutes integrate violations of other statutes. Many of our statutes do the same. So you might violate X, Y, or Z law, and that itself would be a violation of one of the large whistleblower statutes. And I see that as a trend in some of the emerging statutes that I have looked at from the EU. Would I be correct in that, Gabriel?
Quite to the point, yes. It's obvious that the implementation of this directive is, let's say, both an actual legal measure, naturally, but also a political statement by the European Union towards, let's say, having the trend of whistleblowing encouragement that, I understand, obviously exists in the US.
You know, the other point that you made, which I had concluded myself, but I would only speak to myself because I was afraid to utter it out loud, was that as I started to study statutes, the historical and cultural backgrounds of the European countries, I almost could figure out how that law was going to end up. But I kept saying to myself, that can't be true, because the American paradigm, the American system has been so successful. But I've been contacted by legislators in other countries, and whenever I give them the spiel, they say, we're never going to do that here. That's a terrible situation. So I don't know I don't know whether the EU is, in your opinion, is moving in somewhat of a block toward gold standard, if you will, if I could use that term, in protections, or do you still think there's a dichotomy between and among countries? And you made the point of Eastern Bloc and Western Bloc, and your point of your individual discussion with the Netherlands resonated with me, having spent some time in the Netherlands. So I'm just curious as to where you see the future, if there is, as a bloc, or do you think that the European Union will continue to move in a bunch of disparate blocs?
Well, all important enactments by the EU bodies are obviously the result of negotiations between member states. So we can for sure account for that into the, let's say, I would not say halfway, but not complete way of full protections and let's say full speed given to this type of whistleblowing legislation. So obviously, in order to reach enactment of this directive, the EU bodies needed to compromise with the, let's say, more reluctant states into this kind of legislation. However, again, its enactment is obviously a political statement which was reached at the level of all of the EU countries. Therefore, I would say that obviously this is the trend. And not only that, I can see it actually in real life, that this enactment and this political statement by the EU, even before the passing of the implementation deadline of the directive, which again was, the directive was adopted in 2019 and the implementation deadline was December of last year. I saw that this, I call it political, also a political statement, brought actual results in real life. I ended up with a number of clients having a number of whistleblowing issues. And they are also, as in step by step, overcoming cultural burdens into understanding the idea and that this thing is happening. To give you an example, as in one important corporate client was, to my taste, treating whistleblowing things not very serious, because as a major corporation, they are generally treating all things serious. However, because of what I call the cultural approach to whistleblowing, they were not devoting all the resources as in full speed ahead in order to investigate even things that may have been rather serious. And they ended up with, let's say, a lower pace of internal investigation of one particular whistleblowing event, and at the same time being, let's say, caught unprepared by a pending criminal case on the same whistleblowing event. So basically, these kind of things are somehow forcefully bringing people up to speed with the new realities.
Mark, Gabriel, I think that we are at the beginning of a point where, because of the new legislation among the countries in Europe, there's going to be a synergy between the European protections for whistleblowers and the availability of actions that can be taken by various agencies of the U.S. government. And by that, I mean that in the past, where whistleblowers may have been hesitant to either come forward with information to their own governments or to contact counsel to bring their information to the attention of U.S. authorities. Now that they don't have to be concerned about retaliation in their own country with their own companies, I think it will, over time, make it much easier and much safer for Europeans to come to the U.S. or to provide their information to U.S. authorities, where in cases where they could not receive an award in Europe, or the prosecutorial authorities don't have as robust robust statutes and mechanisms to punish wrongdoers. You know, the United States, we have this attitude that our jurisdiction covers the entire world, and certainly our statutes are drafted in a way that virtually any company that does business in the United States, certainly any company that's a public company, is subject to our laws and regulations, even though the criminal activity is happening in Europe or the Far East. It impacts the companies doing business in the United States. And so I think there will be many opportunities for whistleblowers in Europe to provide their information safely to U.S. authorities so that actions can be taken based on their information.
There's a couple of interesting things that maybe go to what Gabriel was saying that John could address easily. So if an American company is charged with a crime, it finds itself at sentencing, John, as a good criminal defense lawyer, the type of compliance programs that were in place in hope of mitigating the sentence. And that is the way in which the United States companies have integrated. Am I correctly stating that, John?
Yes.
Yeah. The other part that John just mentioned is what I would call both globalization, and I'm always afraid to use that term now because I'm not sure what it means, but the reach of some of our statutes, and I'm thinking particularly of Foreign Corrupt Practices Act. You know, you can again have an American company that's doing business in the Congo and finds themselves in a bribery situation that's then lied about, that is of significance, that leads to an alteration in earnings that then leads to a specific whistleblowing event under the Securities and Exchange Commission program. So they are designed to, I think, adopt and acknowledge the fact that, at least from the American point of view, our companies are doing business everywhere. And it's interesting when I get calls from, sometimes in the late into the evening, depending on what part of the world it is, from EU lawyers. I'm always struck by two things. One is that they speak impeccable English and are very sophisticated to multiple states that are going on. But number two, they're concerned oftentimes with their clients who are moving from one particular state to another with no protections that are consistent. And sometimes they might, you know, we've had to work out where we'd have to meet the client to provide protection to that client because he or she has potentially explosive information that might bleed over 3 or 4 potential statutes. So that's an interesting dilemma, and I feel bad because if you're in Romania and you cross the border to someone else, and I'm sure you have memorized all the laws of your border states, but you can't really depend on the same treatment, which I think can be somewhat problematic when, I'm sure, Gabriel, when you are advising clients, which I'm sure you do on a daily basis.
Thank you to Mark and to John and Gabriel. I will now invite our speakers to please state your closing remarks, and then because we've already passed the 1 hour mark, we will be taking on questions from the attendees. So please, whoever of you wants to begin, John or Gabriel?
I can do it. Fully agree with what was said earlier, that probably the new developments in the EU legislation, probably very likely the developments in the EU legislation will bring forward synergies regarding whistleblowing mechanisms between US and the EU. Basically, US is EU's largest commercial partner and ally. So it wouldn't be surprising that again, rather newly developed whistleblowing mechanisms will go back and forth from within the EU towards the US in respect of basically the huge volume of business dealings involving both jurisdictions. Also, one particular, let's say, more legalistic thing regarding what John said earlier regarding, actually both John and Mark, regarding compliance programs. These will compliance programs that will need to be devised also very properly devised, and probably the US jurisdiction would be a very good inspiration source on that, in respect of how to handle whistleblowing, the whistleblowing channels, the whistleblowing mechanisms, such as to cover, from my perspective, 2 important things. One of them being what we call here the subjective side of a potential crime, meaning to show that corporation did not has in place compliance programs and proceedings meant to prevent perpetration of illegal things. So basically to safeguard their proper activity. So therefore, if something wrong happened, it was a rogue thing and not something attributable to the organization itself, or even if the judiciary would hold that a specific deed is also attributable to an organization, at least to use those compliance programs also in terms of how to handle whistleblowing events as mitigating factors in sentencing.
I think that that in terms of a message that I would have to members of Wolep and other European lawyers is that they have an opportunity to spread the American philosophy that whistleblowers are good people who see bad things, get frustrated when their companies won't address those things, and only as a last resort go to the government to make their disclosures. And that's why whistleblowers are celebrated in the United States for sometimes very courageous acts. And the American experiment, which has been going on for 200 years, has not resulted in the kinds of problems that Eastern Europe experienced with informants, because what is happening in the US is very much supervised by our judiciary, and is not designed or intended to simply be a way that the government can keep tabs on the population. So to the extent that European lawyers can spread the word that this is something that can be of vital importance to their own countries, their own companies, and that we in the US are available to help.
No, I echo, I'm sorry, I echo those comments. I think that to follow up on what John just said, I think that whistleblowers generically in the United States, in some respects, may have replaced the position that our press once had, our free press once had. So at times the press was seen as the entity, and now I think whistleblowers often come forward and act as a way to expose things that need to be exposed. I think if one were to look at all of the issues that the EU countries are having or have debated, whether they fall on the progressive or regressive, and that's a subjective term, I understand that, Gabriel, but I think we've debated all those things. Now, we might fall on one particular area or another, but as John said, we have a tremendous body of case law that's developed, at least around the False Claims Act. There are protections in place that I think have found the right balance between whistleblowing, where the Department of Justice is, and the outcome. But I think the other area is that there isn't a consistent prosecutorial authority that has the jurisdiction to take care of the particular laws that might be passed. And I think that's an area that I have, at least in my limited experience in studying some of the EU laws and initiatives. And sometimes I get excited when I see something passed, and then I wait 10 years for implementation, which tells me that I don't understand the system well enough, so that I get on the phone to some of my European or EU contacts and they explain it to me. So those are some of the areas that I do think the EU could benefit. And even if a healthy minority of countries decided that fraud, waste, abuse, and corruption needs to be resolved for the benefit of the citizenry, and there is a methodology in place, and by no means, and I think John, I would speak for John, are we the paradigm of virtue and perfection in our laws, because we are not. One area we do seem to have made advances on is the area of whistleblowing. I'll tell you a funny story. A rather conservative justice who is no longer alive on our Supreme Court had a challenge in front of him brought by American companies to try and get rid of the False Claims Act a number of years ago. And they argued it was not constitutional, and the particular Justice Scalia, who is no longer with us, looked at the statute, decided that when the founding fathers were around, there were whistleblowing statutes. So therefore, how could he strike it as not being constitutional when the very people that penned our Constitution knew that those statutes were around? So I throw that as an interesting anecdote that shows you how far back we go. And I wish you all the luck as you guys move through your statutes. Thank you very much for inviting us.
Thank you, Mark, for the anecdote. I think everyone enjoyed it, and it stays true to this day. To state my closing remark as well, I would like to point out that the invitation that all of you extended to your colleagues, either from Europe or on the other side of the Atlantic in the United States, to take inspiration from each other's legal systems and provisions, including the ones regarding whistleblowers, is truly inspirational. And I think it also extends very well to the principles of Wolep, to the principles of our network of fostering collaboration between lawyers, between colleagues from different countries and continents. So as we end this presentation, I would like to thank you again for taking the time. I know it's a holiday season, so at least in Europe, I don't know how it is in the United States, but I presume it's the same. So because this is probably the last webinar before the holiday season, even for lawyers, I would like to thank you again, and also the attendees, because I know they've made efforts to log in and connect with us. So now, because we have some 10 or 15 minutes left for this meeting, I would like to invite our attendees to address questions to our keynote speakers. Feel free to unmute yourselves and address the question to one of the speakers or all of them. As you've seen, they're very generous and will surely take up your questions. Please. Okay, so I see that we have a question. I will read it out for our speakers. It's from Mr. Gerald Robinson. Thank you for Mr. Robinson for the question. So Mr. Robinson says that the extraterritorial reach of the US Foreign Corrupt Practices Act to prosecute an executive of the French company Alstom is still criticized in the French media as an overreach of US power and viewed by some as a tool that helped General Electric purchase Alstom in the wake of the bribery prosecution. Has such criticism of the extraterritorial reach of US laws adversely impacted the willingness of European countries to pass similar whistleblower laws? So that is the question by Mr. Robinson to our speakers. Feel free to answer.
I guess I should answer that.
I think so.
Sorry, Mark?
No, I think you should. Right.
Tradition, and especially France, is a very is perceived as a very as a state very keen about its sovereignty, and it's not the only one within the EU. There are nowadays even very fierce discussions about the elements of sovereignty shared even between the member states and the EU itself, let alone the idea of be seen as a majority of under one EU member state's jurisdiction, such as France, which is obviously a very important member of the European Union, somehow, let's put it, hijacked by the US, as the French probably saw the problem. However, it's probably more of a matter of national pride rather than a very legalistic issue. To what extent this kind of national pride matters are going to, let's say, delays or reluctance into implementing this kind of legislation? Probably to some extent, yes.
Thank you, Gabriel. If Mark or John want to intervene and add up to this answer, they are free to do it.
My addition would be only anecdotal and frankly not legal. Whenever I land in a foreign country, foreign to America, I always like to read the newspapers. I like to read about European scandals. They're somewhat different than our scandals, because many times our scandals have at the core, as John mentioned, some whistleblower came forward and then somehow the house of cards fell. So that's a very good question from Mr. Robinson. And I hope that doesn't impact the passage of statutes. I mean, as I mentioned earlier, I've spent a fair amount of time on cases in France, and I've gotten to know some of the infrastructure of the French system. And there's a lot of things that they have been trying to do that I think are quite interesting. I think there still are some implementation issues. That's my vantage point. That's not from a French lawyer's point of view. But I do see a lot of things that they have tried to do that are similar to or have surpassed some of the American laws on the books. So it's interesting to see where countries go.
There's also been, over the last 10 years or more, a great deal of cooperation between U.S. law enforcement authorities and whether it be the law enforcement authorities in the United Kingdom or France, where information has been shared, and when there has been a final settlement against a major corporation, monies that are collected under U.S. law are shared with their European counterparts. So we've also sort of indirectly, European law enforcement agencies have also, and governments have also benefited from whistleblowers from Europe coming forward to American authorities, and there has been very good cooperation between the law enforcement agencies of the various countries.
Yeah, I have to echo that. I recently had an experience with Estonian authorities, and I really had never had any dealings, and I was impressed at both the cooperation and the meticulousness and concern about due process as I worked my way through the particular issue. I've never dealt with any Estonian authorities, and I jumped to certain conclusions on Eastern Bloc, Western Bloc, they were all wrong. So it's always a fascinating point of view when lawyers get to interact with other lawyers. At least I find it interesting. And I was very, very impressed.
Thank you, Mark, for sharing this experience with us, and also to our speakers, John May and Gabriel Albu, for adequately answering to Mr. Robinson's question. Thank you. Okay, so if we have a second question, we are all set from the other participants. You can unmute yourself.
Hello, everyone. It's Christian Kalchev from Sofia Bar Association, Bulgaria here. Bulgaria is actually, I believe, one of the EU member states that has not enacted any, that has not transposed the Whistleblower Protection Directive yet. So I frankly have no experience in the sphere of whistleblower protection. I do have some experience in with regard to the European Convention on Human Rights, and in particular Article 10 of the ECHR, the freedom of expression under the ECHR. And throughout the whole webinar, I was kind of looking at this topic through the prism of freedom of expression. So my first question would be to Mr. Gabriel Albu, and it is, in the absence of a robust whistleblower protection legislation in the EU, do you think that the rights of whistleblowers and their freedom of expression could be safeguarded through the mechanisms that the European Convention on Human Rights grants, and through the European Court of Human Rights by means of invoking Article 10 of the European Convention on Human Rights, the freedom of expression? This is my first question. And my second question would be directed to Mr. Raspanti and Mr. May. Now, I realize this may open up a whole new can of worms here, but I would be interested to hear your opinion on whistleblower practices in the public sector, and in such cases, where exactly should we draw the line between freedom of expression of the whistleblower and the public interest. For instance, in cases where the information pertains to national security and such highly sensitive information.
So if we are taking it in, should I go first?
Yeah, sure.
As in prima facie, is a very good question actually to look at the thing through the freedom of expression under ECHR. As in off the top of my head, I wouldn't see safe for let's say an extensive interpretation of the principles laid down now in the whistleblowing directive regarding protections to whistleblowers. I don't see that the protections of Article 10 from the European Convention would themselves be sufficient for a robust protection of whistleblowers. And I will explain why. Because basically the European Court for Human Rights acknowledges that freedom of expression is not an absolute right, and kind of thoroughly lists various types of admissible limitations of the freedom of expression. And then those would be obviously limitations under law prohibiting formally disclosure of some information, under contractual arrangements such as employment agreements, confidentiality clauses in commercial contracts or various types of contracts and so on. So simply freedom of expression, given that it is a right subject to limitations, I don't see it as a sufficient enough protection in whistleblowing contexts. Again, the safeguard for this should be an extensive interpretation of the principles of protections for whistleblowers now laid down in the directive, as they would be from time to time implemented in internal legislation and probably at some point interpreted by, construed by the European Court of Justice.
So very briefly, if you want me, and I'm going to use this as a gross generalization, under the American laws, if we amalgamate all of them, the information is generally transmitted to a prosecutorial or investigative authority. That authority gets to vet the information and make a determination of its accuracy. There are exceptions. National security is at times one of the exceptions. I think we have a pretty good system in place. It's not perfect. There are areas where there is not a clear understanding of how it's to be done, but generally it is done in a way so that the whistleblower is protected and the potential defendant is protected against information that may be inaccurate or inappropriate or just damn wrong. Ultimately, the prosecutorial authorities can decide they don't want to go forward with the case if they vetted it. The difference with some of our laws, not all of them, with some of our laws, is that the whistleblower himself or herself can still go forward with the case. But as John May mentioned, then he or she will also be subject to the prism of a judge who will take a very active role in making sure that the litigation is handled appropriately with the right protections in place. That's a very short answer, a very, very complicated question, but a good question.
Thank you, Mark, and please unmute yourself.
Theodore, how much time do we have left? I want to answer another part of Mr. Kalchev's question.
Well, I think we have time for your answer and maybe one final question. So, thank you.
Okay. I think you were also getting to issues having to do with disclosure of national security information. Is that correct?
Yes.
Okay. The rules are a little bit different when it comes to national security information, only because employees of like the Central Intelligence Agency or the NSA have entered into contracts with their agencies subjecting them to either prosecution or lawsuits if they disclose national security information. And consequently, we've had, and they're not protected by the First Amendment. Our First Amendment is very broad and works very successfully, allowing us to express ourselves. And indeed, the press is protected. The unusual circumstances in the United States is that the person, the employee, let's say, of the Pentagon, who releases information may be subject to prosecution, but once it's in the hands of the press can disseminate it to whatever extent they want. And the press isn't subject to prosecution, but the journalist who wrote about it, that sometimes in some circumstances can be compelled to disclose the identity of the whistleblower. And in most cases, the journalist doesn't, and may spend a few weeks in jail under contempt, but eventually the press comes out the winner. But in cases of the whistleblower themselves, in the area of classified information, secure information, they are in some jeopardy. And a number of people have been prosecuted and have gone to jail. And some people are living in Russia.
Right.
So that's a dicey situation for a whistleblower.
Okay, thank you, John, Gabriel, and Mark. I think the answers were pretty comprehensive for Christian. Thank you, Christian, for the very interesting question that you addressed. So we have time for another final question, if that is the case, please. I would also like to thank everyone for walking the extra mile with us, because I know that we set an hour and a half for the webinar, and we've passed that mark. So one final question, if that's the case. If not, I did have one short question for our speakers, because I've noted something, but again, I would not like to steal the spotlight from our attendees. So if anyone has a better question than mine, I'm sure they can address it. Okay, you can interrupt me whenever you want. So it's a question that applies to all of our speakers. You've mentioned many times, or better to our American speakers, you've mentioned many times the anti-retaliation provisions in the various US whistleblower statutes. And I would like to ask you, Mark and John, but also Gabriel, maybe in Europe, how are these whistleblowers that come forward protected, and how is it enforced in in the sphere of maybe coming out and do these disclosures? How does that work? Is there an agency, maybe the US, that generally protects these whistleblowers, these persons that come forward with these various disclosures?
So I could take a stab at it. We're talking about anti-retaliation, but I'm going to use an amalgamation of some of the statutes, because they're not all the same. Let's take the greatest protections that exist for whistleblowers under our statutes. If one comes forward under the False Claims Act, for example, and files his or her suit, even if the suit is dismissed or is found not to be perfect, that the act of whistleblowing, the act of coming forward, is protected that whistleblower can be reinstated to his or her job. They can have all of their back pay reinstated. They can receive double damages. They can receive attorney's fees. And frankly, the statute even has language that says anything else that will make them whole can be provided to that whistleblower. Typically, under the False Claims Act, at the end of the day, our federal courts decide what is going to happen or how they're going to be protected. Some of the other whistleblowing statutes that we mentioned early on in the PowerPoint are dependent on the agencies that are involved. And some of them have stronger protections than others. There are also whistleblowing statutes that exist that are embedded in many other statutes that exist in the United States. Not all of them have the same teeth as the statutes we've mentioned, but they do provide an increasing amount of protection, and at least under American law, more and more as a piece of legislation is passed, it's embedded with some type of whistleblower protection because legislatures see the wisdom of some of those. Not a perfect system. It's not always a quick system, but it's a pretty good system because generally one can look to a statute or a provision and see what protections can or should exist if that person makes out the case.
Thank you, Mark. If John wants to add to your answer, if not. Okay. So again, I would like to thank everyone who was involved in preparing and into making this webinar come to life, come to fruition. So thank you, first of all, to Mark, Gabriel, and John for accepting our invitation. It was a pleasure and an honor from all of the people at Wolep to have you as speakers. And I hope in the future we'll also have a chance to convene physically, maybe at a Wolep event somewhere in the world. And second of all, I would like to thank you for again for taking the time, because I know it's a very complicated schedule that you all have. So that would be all for today. Thank you, and don't forget that we will be sending you the presentations of all of our speakers and also summary of today's proceedings. So again, thank you, and may you have a great day or a great
Thank you very much.
depending on wherever you are.
Pleasure to be in such.
Thank you. Bye-bye.
Bye-bye now.